April Keeler versus Daniel Miller. Attorney Jennifer Reed for defendant.
Okay. Good afternoon to all of you. This is the time and place of the evidentiary hearing on the defendant's motion to modify custody, parenting time, and support in this particular matter. And Ms. Reed, are you ready to proceed?
Yes, we are, Your Honor.
Okay. And Ms. Keeler, are you ready to proceed?
Yes, sir.
Okay.
The parties in this matter are the parents of Keon. He's 13 years old. They currently share joint legal custody and joint physical custody. On May 8th of this year, there was an incident where Miss Keeler assaulted Keon by scratching his neck and choking him with his hoodie. Miss Keeler has been charged with child abuse third in that matter, and that matter is pending in the circuit court right now in case 23-1674-FH. There is a current PA 53 no contact order between Keon and Miss Miller. Mr. Miller is requesting that he be awarded sole legal custody, sole physical custody, and that Miss Keeler complete an alcohol assessment, parenting time classes, anger management classes, and then once that no contact order is lifted, that she participate in some reunification counseling with Keon before she can then motion the court for reinstatement of a parenting time schedule. He's also requesting a modification of child support pursuant to the formula.
Okay, thank you. Ms. Keeler, do you wish to wish to make an opening statement, or you can reserve on your opening statement and make it before you present any evidence or proofs, or you can waive your opening statement. What would you like to do, ma'am?
I'll do an opening statement.
Okay, go ahead.
I would ask the court to wait for the other case to be dismissed before making a decision. I also would like to show the courts a video that I have of the alleged legislations of the incident. And I would just ask for the judge to hold off to make any decisions until the other case is dismissed or whatever happens. And I'd also like to share my videos.
Okay.
Double check and
I'm just checking to see if we put some notice in on the time.
I believe we had to exchange exhibits at least 7 days before the hearing, and I haven't received any exhibits.
That's what I was just checking on to see that that's the case. Once we get confirmation of that, Ms. Keeler, then you would not be able to present the video because that was not exchanged as per the requirements of the notice of this particular hearing. So.
And yes, we stated clearly, provide judge's copy.
Well, no one has talked to me about anything neither, Your Honor.
Well, ma'am, it's on the notice. It's on the notice that you've got of today's hearing. So we didn't have to call you up and talk to you because it's on the notice. So, okay, with that, we'll proceed. You could have, Ms. Keeler, you could have, if you wanted to adjourn this matter, you could have filed a motion and requested the court adjourn it, obviously give a reason for the adjournment. You have not done that until today's date, so it's a little bit late to request an adjournment in this matter, especially when we don't know the other case. We don't know when that's going to occur or what's going to happen in regard. So court in this matter will proceed with the hearing today because everybody's ready and there was no prior request to adjourn the matter. So Ms. Reed, you can begin with your proofs.
Is Officer LaValley present?
This is the first court date we've had.
Excuse me, ma'am?
This is the first court date I've been in front of a judge. I've not been in front of a judge for this case. I do not know what to do. No one's representing me. I'm unaware of anything that needs to be done. This is the first time I've had a court date, face-to-face talk conversation with anyone.
Well, let me tell you, that's back, if you remember, back on May 30, 2023, we had a motion hearing, and that motion hearing, you attempted to join vis-a-vis, again, the virtual like you're doing today, and then there were some problems. You had some problems. You were not able to join. So what we did is we moved that 1 week and then had the motion hearing on June 5th, 2023. And at that time, you did not appear. And at that point, then we proceeded on the motion and then set this matter for hearing. So You did have notice back in May that this matter was coming before the court and had not taken any action. So that's unfortunate, and it's sorry, but you have a responsibility when you represent yourself to make sure that you do everything just as if you were an attorney, because you're taking on that responsibility when you don't receive representation. So we are going to proceed with the matter. So Ms. Reed, you can call your first witness.
I'd like to call Officer LaValley if she's present. And where are you currently employed?
The City of Battle Creek Police Department,
And how long have you worked there?
approximately 2.5 years.
Okay, did you respond to a call on May 8th of this year involving,
Yes,
what was the nature of that call?
an assault occurred.
And what time did you respond?
Call came out approximately 21:26, I believe.
Okay, and then was the incident resolved by the time you got there, or was it still ongoing?
Keon was getting checked out by Life Care and Scene.
Okay, and then what did you see on the scene?
Keon was getting checked out by Life Care, and I observed that he had a fresh red scratch mark on the back left side of his neck.
And did he have any other injuries?
He did not.
Okay. And had anyone else been responding to that call?
What was that question again?
Had anyone else responded to the call?
My partner, Officer Scott.
Okay, did you have an opportunity to talk to Mr. Miller about the call?
Yes,
And what did he state occurred?
that he got a phone call from a Carrie Frisbee, which was Keon's grandmother, and that he answered the phone and it was Keon crying, and that he told his dad that his mother, April Keeler, had just choked him.
Okay. Did you see any red marks other than the scratch on Keon's neck?
I just seen the scratch, the fresh red scratch mark on his back side left, on his left side of the neck.
Okay. And did you have an opportunity to talk to Mr. Keeler about, or Miss Keeler about the incident?
My partner and I went to Roxbury Lane, where April lives, and we made contact with her at the door, but she was not willing to come out and speak to officers on scene. That we spoke through the glass door at her.
Okay. Did she give you a story contrary to the allegations?
What was that question?
Did she give you any story contrary to the allegations from Mr. Miller or Keon?
I asked why Keon had marks on the back of his neck, and she stated that there was no marks on the back of his neck, and that she was very uncooperative with us on scene.
Okay. And then based on your investigation, did you make any recommendations for charges to the prosecutor's office?
Yes, I submitted the assault with intent less than murder for strangulation.
Okay. And was CPS contacted?
Yes.
Okay, I have no further questions.
Okay. Ms. Keeler, do you have any cross-examination of Officer LaValley?
When the ambulance there looking over Keon, do you know what happened to Keon after that, if he went to the hospital or did?
What was the question? You keep going in and out.
When you witnessed Keon getting checked over by the ambulance, did Keon end up going to the hospital, or do you know what happened to Keon after that? Do you know if Keon went to the hospital when the ambulance were checking when the ambulance people were checking him out?
Looks like the officers froze up again, so we'll have to,
All right.
okay, Ms. Keeler, if you'd ask the question again.
When the paramedics was checking Keon out, do you know what happened to him afterwards? Did they end up taking him to the hospital?
I do not recall if he was taken to the hospital, that he was still in the back of the ambulance with Daniel.
So you're not aware of him going to the hospital in the ambulance and the hospital not even doing x-ray or anything and releasing them and telling them to go home because there was nothing wrong?
I'm gonna object, Your Honor, that was asked and answered.
So you
Well,
have no,
I'll allow it. It's
my
cross-examination. Go ahead, ma'am.
so you have no recollection of my son going to the hospital in an ambulance. They did no x-ray and they didn't admit him. They didn't check his neck or nothing and told them to go home. Is that correct?
I was not provided any of the information. I did not go to the hospital with Keon.
So you're not aware that happened?
Like I said, I was in the parking lot sitting with the ambulance with Keon and Daniel before when I left to go chat with you on Roxbury Lane. They were still in the parking lot.
Okay, you also said that I was uncooperative at the house. What was I doing to be uncooperative?
What was the question again?
What was I doing where I wasn't cooperating with you and I was being uncooperative when you came to my house?
We asked you multiple times, April, to come out in the yard and speak with us, and you refused to do so. You refused to open up your front door. We talked through the glass door with each other. You kept cussing at us.
Okay, so because I didn't open the door and I didn't come outside, I was being uncooperative, or I was answering all your guys' questions and everything you asked me? Did I not answer any of the questions you asked me?
Well, it looks like she's froze up again. The question that Ms. Keeler asked was, did she not answer your questions?
I asked her a lot of questions. And I remember that she was cussing at us. And then she basically told us that she didn't trust us and that she left the front door and she refused to talk to us anymore, which I had additional questions with her.
So you didn't ask me why me and Keon got into it or if we got into it that night?
You had mentioned that quotations, he got to talking his shit and that wasn't not listening.
So what more did you need to ask that I didn't respond to?
So I was investigating the scene. I had multiple questions for you and you kept saying that you didn't trust officers and basically you didn't want to talk to us.
No, I just didn't open my door, but I definitely was talking to you guys. Anything you asked me, I answered.
Ms. Keeler, just to clarify for you, this is your time to ask questions, not to argue with the officer. You'll have a chance to testify yourself later and you can add all of that information in.
Okay.
Do you have any more questions, ma'am?
No.
Okay. Ms. Reed, any redirect?
Briefly, Your Honor, Officer LaValley, did you prepare an incident report, an investigation after you concluded your investigation of the incident?
What was the question again? I'm not understanding.
Did you prepare a report regarding this incident?
Yes, I did complete a report.
And did you take pictures during the incident in your investigation?
Yes, I did.
And did you attach photos of those photos to your report?
Yes, I submitted to the BCPD lab.
Okay. Your Honor, may we have Exhibit C on the share screen? Officer LaValley, can you see what I'm sharing with you?
Yes.
Does this look like your incident report? I'm going to scroll slowly. Let me know when you want me to stop.
Yes, it does.
Okay. I'm going to scroll a little bit further, pictures that were attached to your report,
Yes,
and it's kind of hard to see on my computer, but is that the scratch on the back of Keon's neck?
yes,
And you indicated that it was fresh?
correct.
And how did you determine that it was fresh?
It was red.
Okay. And has this report been altered in any way other than myself adding the exhibit sticker to it?
No,
Okay, at this time, Your Honor, I'd like to move for the admission of Exhibit C.
Well, I'll tell you, without any response from the plaintiff, I do not admit police reports. The officers here can testify. It would be redundant. I have no problem with admitting the pictures, but I will not admit the police report.
Okay, so we would request that the pictures be separated and then remarked as Exhibit C.
Okay. Ms. Keeler, do you have any response to the admission of the pictures?
Is that the only thing he had on his neck was one scratch on the back of his
Ma'am,
neck?
this is your chance to respond to the offer of the exhibit, not to argue about the exhibit.
What do you mean offered to the exhibit? I'm not understanding you.
The exhibit is being offered as an exhibit and as evidence in the case. If in fact you have a proper objection, you have a right to object to the exhibit. Otherwise, the exhibit will be admitted.
Oh, I object.
Okay. Well, in this particular matter, the plaintiff objects, but is not a valid objection. The court will admit defendant's Exhibit C, consisting of 2 pictures of Keon.
Okay, I have no further questions.
Okay. Ms. Keeler, do you have any additional questions of Officer LaValley?
No.
Oh, okay. Thank you, Officer LaValley. You are excused, and you have a wonderful day.
thank you too.
I'd like to call Shelley McCall. I'd like the court to order Ms. McCall answer some specific questions regarding a CPS investigation. As CPS investigations are confidential, she would require that order to be able to testify.
Okay. The court will allow Ms. McCall to answer the questions as it relates to any CPS involvement.
And
Thank
where are you currently employed?
With the Calhoun County Department of Health and Human Services.
And what department within the Calhoun County Department of Health and Human Services do you work for?
Children's Protective Services.
Okay, and what position do you hold there?
I am a CPS supervisor there.
Okay, and what is your involvement with the case with?
My current involvement is I am the supervisor of the current ongoing CPS worker, Christine Eaton, who is currently involved in providing ongoing monitoring and services for the case.
Okay, and how did this case get to CPS?
We received allegations in approximately May of this year regarding concerns regarding physical abuse of the child by his mother.
Okay, and was an investigation launched?
Yes, it was.
Okay, and who was interviewed during that investigation?
The father, Daniel Miller, was interviewed, the child, and the mother, April Miller, or Keeler, I'm sorry, was also interviewed.
And as a result of that investigation, were there any substantiations made?
There was a substantiation made. April Keeler was substantiated for physical abuse of the minor child.
Was she placed in the central registry?
No, she was not.
Okay. And was she cooperative in the investigation?
From what I can tell from the report, she was cooperative when Miss Hughes finally made contact with her, but it took some doing to get her to respond to Miss Hughes.
Okay, and are there any sort of recommendations in the continuing services case?
Well, my current worker, Christine Eaton, has not been able to have any successful contact with April Keeler. She has attempted regularly to try to contact Miss Keeler by phone. Text message has gone to the home several different times. The first contact that Christine attempted to make after she was assigned the case, April did answer the phone. When Christine began to identify who she was and her role, April became very agitated, began yelling, and hung up the phone. Christine has not had any contact with her since that time. Our hope would be to, obviously, when we open a case, we always try to implement services to address the issues and to improve the situation, and that's not been able to be accomplished so far.
Okay, would CPS recommend any sort of anger management programs?
Yes, that would be the discussion we would have with Ms. Keeler, is that she involved herself in anger management classes, individual counseling services, as well as possible family counseling for herself and the child.
Would parenting time classes be recommended?
Yes, that would also be a possibility, yes.
Okay. And have you talked to Mr. Miller about these concerns and recommendations?
To my knowledge, Christine has met regularly with Mr. Miller and yes, has discussed this.
Okay. And are you aware that there is a current no contact order between Ms. Keeler and Keon?
Yes, that's what Ms. Hughes's investigation indicates, that there is such an order in place.
And because of that order, there's no concerns for Keon at this time, is that correct?
That is correct.
Okay. Would CPS have concerns if Keon had parenting time with Ms. Keeler right now?
Yes, absolutely, because she has not engaged with us at all. Even during the investigation with Ms. Hughes, she continued to voice that no child was going to disrespect her in her home. She reluctantly agreed to a safety plan where we had asked that she not incorporate any kind of physical discipline with Keon, and she indicated that she would sign the plan, but still nobody was going to tell her basically how to discipline her child, and that her child was not going to disrespect her.
Okay. I have no further questions.
Okay. Ms. Keeler, do you have any questions of Ms. McCall?
Have you ever seen the videos of the allegations?
I'm sorry, you broke up through part of that.
Have you ever seen the videos of the allegations?
I have not viewed the video myself, no.
Are you aware I have a 17-year-old daughter?
Yes, I am aware of that.
So because you have not had contact with me on an allegation, you feel my son ain't safe at my house where he's been the last 10 years?
We've made multiple attempts to have contact with you, and you have not responded.
You did not answer my question, ma'am.
Could you repeat the question, please?
I said out of the last 10 years that I've had my son, you feel because of an allegation, my son is not safe with me, but my daughter was the last 17 years that I raised him?
Well, all I can say is the allegations the allegation of the physical abuse was investigated, and it's no longer an allegation. A preponderance of evidence was found that indicated that the situation or the incident did occur and he was injured as a result.
Have you seen the videos on it?
I have not seen the videos. I have read in Ms. Hughes's report the description of the video.
So you're just going by he said, she said at this point?
I am going on what the investigator did during her investigation of the matter.
Not the facts that's in the recorded videos.
I believe the videos have been included in the investigation and have confirmed that there were concerns.
No, ma'am, they have not been a part of the investigation.
I object, Your
Hold
Honor,
on.
she's testifying.
Ms. Keeler, again, this is the time to ask questions, not for you to testify. So,
Okay, have you seen the videos, ma'am?
I've answered your question previously. I said, no, I have not.
Okay, again, so you're going off allegations of what somebody else has said, right?
The allegations have been investigated.
But they have not seen the videos. Have they not seen the videos of the proof of what had happened that night?
I'm going to
It-
object, Your Honor. The witnesses testified that Ms. Hughes had seen the video. They were incorporated into the report, and that based on the video, there were still concerns.
Okay.
Well, if CPS has the videos, I would like them to be shown, Your Honor.
Okay, ma'am, what
Okay.
happens is, again, I'll go back to your offer in this matter. You did not submit the video as an exhibit or a proposed exhibit. As a result, the court is not going to admit something that was not submitted and provided to the other side. It would be unfair to, again, admit an exhibit that was not exchanged under the direction of the court.
I don't understand anything you just said, but continue on.
Go ahead, ma'am, ask your next question.
I'm thinking. Hold on, sir. Did you ever have contact with my daughter?
I'm going to object, Your Honor. I don't see how her daughter is relevant to Keon.
Well,
She's
I don't know. I don't know all the facts yet. I'm going to let her answer it just because I don't know if the daughter was present or not. So I'll let her answer.
The only answer I can provide is Miss Eaton did go out to Miss Keeler's, or during one of the times she went out to Miss Keeler's home, her daughter did answer the door. And Christine, spoke with her briefly about, was her mother at home, and that Christine was trying to make contact with her mother. And at the time, the daughter indicated that April was not available.
Did she ever question my daughter?
Christine, no, would not question your daughter. She was trying to make contact with you.
So she didn't think it would be irrelevant to her kids' opinion on what's going on in the house?
Christine is not the investigator. I'm not aware that Miss Hughes spoke with your daughter either during her investigation.
Well, wouldn't that be something you should do for any kid that lives in my house? If you guys felt a certain type of way that my son was in danger, wouldn't you concern yourself with my 17-year-old daughter that's in the house?
We were not aware that your daughter is living full-time with you. In fact, I was informed that she was, at the time Christine made contact, that she was just at the home at that time.
And who is saying this?
Christine Eaton, who was the assigned CPS ongoing worker.
So my daughter just happened to be there the one time she showed up and I wasn't?
That is correct, because that's the only time Christine has come in contact with your daughter, and she's been to your home multiple times.
Have I been there multiple times when Christina has been there?
I'm not sure, because no one's answered. You have not answered the door. So I don't know if you're home or not during those times.
Did they ever leave a note, a contact number stating they were there? Did they leave any evidence?
I don't know. I know that Christine has informed me she's tried to call and text you as well.
Well, I would like to see them because I do not have one text from them. So I would like to see that proof.
Okay, well, you can ask questions now, Ms. Keeler.
Okay, you can continue.
There's no question on the,
Thank you, George.
Ms. Keeler, do you have any more questions?
No, sir.
Okay,
I have no further questions, Your Honor.
okay. Ms. McCall, thank you for your testimony. You're excused. You have a wonderful day.
Thank you so much.
Next witness.
I'd like to call Daniel Miller. And you share one child with Miss Keeler, is that correct?
That's correct.
And that is Keon,
Yes.
and he is 13 years old.
Yes.
Prior to May 8th, what was your parenting time schedule?
We had week on and week off. He would get a week with her and a week with me.
Okay. And then what happened on May 8th of this year?
I was laying in bed. I think it was about 9:30. I had work in the morning and my phone was ringing. I usually don't pay attention to it, but something told me to look at it. And, I seen Carrie Frisbee was calling, which is Keon's grandmother. And so I picked up the phone and it was Keon on the other line crying. So when I asked him what was going on, he just said, "Can you come and get me?" And that was all he could say. So I got in the car and drove over there. It's not that far away. And when I got there, Carrie met me at the front door. Well, first, as I was pulling up, Miss Keeler was speeding away from Carrie's house, and she was swerving. It looked like she almost hit us. As I pulled in, Carrie met me at the door, and I asked what was going on, and she said her and April, or that's what I'm referring to, and Keon got into it. And I was like, "Well, what does that mean?" And she wouldn't say. As I was standing there talking to Carrie, April pulls back in and walks up the stairs into the door. And then that's when I talked to Keon. He was down the road, hiding behind a tree. So I drove down there, picked him up and took him home. And he told me that him and his mother were arguing. She was driving with open alcohol bottles in the car. And when they got home, it turned physical. And she choked him and put him up against the wall with her forearm, I mean. And he did have marks on him. And so I called the police, and they met me at the apartment and took a report.
What kind of marks did you see on Keon when you arrived?
Keon had a scratch on the back of his neck. The side of his face was red, and I saw redness on his neck also.
Okay. And how long was it between when you arrived and saw those marks and then when the ambulance and the police arrived?
They got there pretty fast. It was probably 5-10 minutes.
Okay. And then did you take Keon to the hospital?
Yes.
Okay. And what did they do at the hospital?
The ambulance recommended we take him to get him checked out because of him being up against the wall with the forearm, just to make sure there was no blockage to his airways. And so they checked him out there and didn't see there was any kind of breathing problems or anything. And they contacted the social worker, I think it was, that's in the building, and then let us go home.
Was he prescribed any sort of medications from the hospital?
No.
Okay. Have you had any sort of behavioral issues with Keon while he's in your care?
I have not.
Okay. Do you have any sort of issues communicating with Miss Keeler regarding Keon?
Yes. She doesn't even, I think she has my number blocked. We can't even talk. Like I can't call her, can't text her. And then if she wants to randomly call me, she'll unblock me and then call or text or something, and then reblock me.
Okay. Do you guys have issues communicating regarding major life decisions like healthcare and schooling for Keon?
Yeah, we do. I mean, there's no communication at all from her.
Who usually makes those decisions?
I mean, if he has a doctor, if he needs something, he needs a doctor appointment or a dentist appointment or something like that, I'll call and set one up. If as far as school and stuff, he's court ordered to go to I deal with a lot of the school and stuff. She doesn't even bother with the schooling at all. They didn't even know who she was when she tried to go in there and pick him up.
Okay. Does she ever attend doctor's appointments, or is it you?
No, I attend the doctor's appointments.
Is she made aware of when those appointments are?
Oh yeah, she knows her. She keeps taking my phone number off of the doctor's notification list. But she'll generally, if she has to, like she did make him one before, and she made it for when he was going to be with me on my week. So I would take him, which is fine.
Okay, when you say when she keeps taking your number off the doctor's list, is she removing you as a contact or just getting your number from there?
No, she's removing my number, and hers is the only number. We just had to set him up a sports physical for football a couple weeks ago, and my number was gone again. And it's happened multiple times. They said the only contact number they had was hers. So they keep taking mine off.
Okay. Can you describe your relationship with Keon?
Loving, I mean, understanding. Keon's a good kid. I mean, if Keon needs something, he'll come talk to you. Like he won't, it's not a big thing. Communication's not an issue. We have a very close relationship, and things that he talks to me and Samantha, my fiance, about. I feel like is probably things that every other kid talks to their parents about. Very close.
What kind of activities do you share together?
Keon's really into throwing the ball, like football, so we've been practicing on that. We play basketball together. He loves playing the video games, so we do that. Even going places, beaches, stuff like that.
Okay, and how do you discipline Keon?
So for me, I mean, life is all about choices, so I try to teach him that. And you always get a choice first, right? And you're having a trouble, then it's you want to clean your room or do you want to lose your phone for the day? You know what I mean? And if we have an issue, then he's going to lose his phone, and that's a big motivator for him. He loves his phone. He loves being in contact with his friends, so that generally works.
And how often do you have to discipline Keon?
Not often at all. I had to probably one time in this year. I took his phone.
Okay, do you have any religious beliefs or practices?
No,
Okay, so Keon doesn't attend any sort of church, school, or camp?
no,
Okay. Do you purchase the items that he wants and needs?
I do.
Okay, and are there any special needs like medical or educational needs that he currently has?
No, he struggles a little bit in school sometimes, and we have to stay after and get a little bit of homework done or get some caught up at home. I think it's a focus thing for him. Everything that he goes through at home with his mom. He was really struggling for a minute there in school, but he's back on track. And at the end of the year, he got his grades back up to B's.
Okay, and that was after that no contact order was put in place, it got a little bit better?
No, this I'm referring to him at the end of the school year.
Okay. So from what time was he improving?
Excuse me.
When was he struggling and when did he start to improve?
Well, he constantly struggles when he's on his mom's week because he misses a lot of school when he's over there. So during the school year this year, earlier in the year, he was missing assignments from the weeks that he was with her because he wasn't at school. Then when he got back with us on our weeks, then we would push and get him caught up.
Okay, do you routinely help him with his homework?
Yes,
And is he permitted to turn in those late assignments to get caught up?
yes, and do extra credit. And he gets to stay over a half hour to actually get extra work done so he can get his grade up. Like take quizzes retake quizzes is a big one that will get your grade up.
And he does that at school?
Yeah, he stays after too.
Okay. Okay, I'm gonna move on to some child support questions. Where are you currently working?
I'm not really comfortable disclosing my work information to April Keeler.
And why don't you want to disclose where you're working to Ms. Keeler?
But I don't want her calling harassing my job.
Has she
Yeah,
done that
she-
before?
She has not, because she doesn't know where I work, but I know she will, or having someone show up to my work or something like that.
Okay, so Your Honor, for child support purposes, can we have it referred to FOC for an investigation?
Well, I think we can probably establish, without establishing the place he works, we can establish income and all of that. That would be probably sufficient for purposes of establishing the support.
And then for the order, when I prepare it, can I list it as confidential?
That's fine.
Okay. So how long have you worked there?
Almost 3 years,
How many hours per week do you work?
40,
And what is your rate of pay?
24.
Is that consistent?
Yes,
Do you receive any sort of bonuses?
no,
Do you receive overtime?
no,
Do you receive any payments from profit sharing pensions or retirement?
no,
Do you receive any military benefits?
no,
Do you receive any sort of public assistance benefits like food stamps, housing benefits, or Medicaid?
no,
Does Kiana have any childcare expenses?
no,
Okay. Do you have any uniform or licensing expenses or other costs that you must pay as a condition of your employment?
no.
Who has health insurance on Kiana?
Keon has Medicaid through his mother's
Medicaid through
in
mom?
this case, right?
Do you have any other sources of income other than your employment?
No,
Okay. What status do you claim on your taxes?
single,
All right. And do you live in a house or apartment?
townhome.
And how long have you lived there?
Been here probably 10 years.
How many years?
How many?
10 years.
10 years, okay.
And how many bedrooms is your townhome?
3.
And does Keon have his own room?
He does.
Okay, and who lives with you?
It's me, Samantha, my fiance, and Keon and her 2 children and our dog.
Okay. And how long have you been in a relationship with Samantha?
About almost 11 years.
Okay, and where do Samantha's children sleep?
They share a room.
Is Keon responsible for any chores or responsibilities around the house?
Yeah, he has to keep his room clean. They all do. And then if we were in it, we might ask him to wash the dishes or something like that when we need help around the house. And
Okay, and do you have any concerns regarding Miss Keeler's home?
as far as
people
Keon's safety,
on the,
definitely.
okay, so what are your concerns?
I mean, I know she drinks a lot, and it seems like their problems come from her drinking. So I mean, and she has done this with her daughter too. I mean, she's
Hold on 1 second, sir. We apparently have lost Miss Keeler.
Yeah, she just dropped out. I have the ringer set as soon as if she comes back.
Okay, why don't we just give it a few minutes and see if she rejoins. The record, the court did note through the testimony of a defendant that at one point when I looked up, it was approximately 2:24 and noticed the plaintiff was not on the screen anymore. And so we took a 10-minute break to see if she would rejoin. She has not yet rejoined. The court would note I've also checked with the office staff, and we've not received a phone call in the office from her either as it relates to joining or any difficulties that she was having. So, Ms. Reed, you can proceed.
Thank you, Your Honor. Mr. Miller, the last question I had asked you is what your concerns are regarding Miss Keeler's home.
just the physical parts that's going on there and her drinking, and it's not something new. You know, it's been an ongoing issue, or the alcohol, and I just feared sometimes, you know, it could get worse, you know, than what happened. And the last thing I want is for something to happen to our son.
Okay, and regarding her alcohol use, have you observed her alcohol use?
Oh yes, we were together for a while, and then she was actually dating a family member of mine not that long ago, and she would be at, you know, family events sometimes,
And was she intoxicated at these events?
but she's always intoxicated.
How often do you see her?
I don't see her anymore. They're not together anymore, so I don't see her anymore.
Okay, is she intoxicated when you exchange, Keon?
She doesn't come to the exchanges. She sends her dad.
Okay. So how do you know she's continuing to drink?
From what Keon tells me.
Okay. And is he upset by this?
Yes, definitely. I mean, the night that she this happened, I mean, when she walked right past me, you could clearly smell it on her. She almost hit me when I pulled in.
Okay. Do you use any illegal drugs?
No,
Do you use any marijuana or marijuana products?
I don't.
Do you consume alcohol?
I do.
Okay, and how often do you consume alcohol?
Every once in a while, we go out with my sister and brother-in-law and have dinner, and we'll have a drink over there. So every couple weeks or so, we go out to dinner.
Okay. Is it in excess?
No, it's just a couple drinks with dinner.
Okay. Have you ever been ordered to participate in a substance use treatment program?
No,
Okay, and do you know if Miss Keeler uses prescription drugs?
I don't know for sure. I know that I've heard that she does.
Are they prescribed to her, or is she abusing other pills?
No, she's like not prescribed to her.
So they're not prescribed to her, you said?
No, she's the ones that are supposed to be prescribed to her. She doesn't even take. She's supposed to take bipolar medication.
Okay. Have you observed her taking other medications not prescribed to her?
Yes.
And when was that?
Just years ago. Yeah, it wasn't recent. It was just when, you know, I was around her.
And do you know if she's ever been ordered to participate in a substance use treatment program?
Yes.
And when was that?
I think it was when she had her drinking and driving and hit that person. So it was years ago she did that substance use or alcohol treatment program, classes, whatever it was.
Okay, when you said when she had a alcohol and hit somebody, was that in 2011?
Yes.
Okay, and she was charged with felony operating while intoxicated, is that correct?
Yes.
And you said she hit somebody?
Yeah, she hit somebody and paralyzed them and then tried to leave the scene of the accident.
Okay, and did she serve any sort of jail term for that?
Yes, she went to prison.
And for how long was she in prison?
3.5 years.
Okay, and Keon was with you during that time?
He was with me and my mother.
Okay. And then we had run an iChat for Miss Keeler. Do you recall us doing that?
Yes.
And then we had submitted that as our Exhibit A. Do you recall doing that as well?
Yes.
At this time, Your Honor, I'd like to move for the admission of Exhibit A, and that is the iChat for Miss April Keeler.
Okay. Can you, again, can you share that?
You should be able to go ahead.
And Exhibit A reflects that on 10/5 of 2010, she was charged with a felony traffic offense. And then 4/28 of 11, that's when she pled to the felony operating while intoxicated that caused serious injury.
You move for the admission at this time, Ms. Reed?
That is correct, Your Honor.
Court will admit plaintiff's Exhibit A at this time. There be no objection.
Other than the recent incident, have you ever had any other CPS contact, Mr. Miller?
Yes.
Okay, and when was that?
It was not years ago. I think April called them or something.
Okay, was anything substantiated?
No. It was
Okay.
come and talk to you and they were gone.
All right. But no other issues?
No.
Okay, are there any physical issues that would affect your ability to be a parent?
No.
Do you have any mental health issues that would affect your ability to parent Keon?
No.
Okay, what school does Keon currently attend? Okay, and what is his attendance like?
It's really good on my weeks. But like I said, he struggles to get to school on his mom's weeks.
Okay. Does he like school?
He loves it. He loves that school.
And what are his grades like?
Like I said, at the end of the year, he had B's and A's. During the year when he was, missing time, he was down to C's and D's.
Okay. And does he participate in any extracurricular activities?
Yes, he does football and basketball.
And do you participate in these activities with him?
I do. I go to every game.
Okay, and does April attend these games?
She attended one of the basketball games, and that was it.
Have there been any incidences or issues when she attends these games?
No, we don't sit by each other, but she doesn't. Basically, the grade he's in, he has an A and a B team in middle school. And when one team's done playing, you're supposed to stay and support your other team that's playing. But on her weeks, she won't let him stay to support his other team that's playing, and she yelled at him when he asked, like, "Don't start with me, Keon," in the hallway. And I even offered, I'm like, "Hey, I'll bring him home to you when the game's over. Can he stay and support the team?" And she won't let him.
Okay. And did that happen on one occasion or multiple occasions?
Well, that was the only game that she came to.
Okay. Are there any instances of domestic violence between you and April?
There was when me and her together. I think 07 or something. We had one.
Okay. And who was the aggressor?
It was her, but I went to jail for it.
Okay. Were you charged with domestic violence?
I was.
And were you convicted of domestic violence?
Yes, I think I did a fine or something.
Okay. And do you recall what year that was again?
I think it was like 07.
Okay. But nothing recent?
No, I don't. Definitely not.
Is there anything else you'd like the court to know?
No, I think that's it. I think you covered everything.
I have no further questions.
Okay. I do, just briefly, sir. That when Keon was in care of his mother, that his attendance was not the best. Do you know how many days he missed in the last school year, which would be 22-23, when he was with his mother?
No, I don't have the exact number of days. I don't want to give you misinformation, but it was, sometimes twice a week, once a week, it was just a constant thing. So, the days did rack up.
Okay. When he'd missed when he was with plaintiff, when he would miss those you said miss those two days a week. Were those full days or he was simply
It was just a
tardy or
regular,
what?
it was just a regular full school day.
Okay. Did you have on the May 8th date, when this incident occurred between the plaintiff and your son, did you have any communication with the plaintiff?
No, she walked right by me and didn't speak when she pulled into her mother's house.
Let me ask you, during the, since you've had Keenan with you since, let's say, May 8th, since that time, has she done anything to contribute anything financially, buying him anything, giving you any money or anything of that nature?
No, she doesn't anyways. Like I told, Miss Reed, I don't even, I don't want her to help. I don't need it,
Well, I'm not asking if you want it. I'm asking if she contributed anything.
No, not at all.
Now, I know that the plaintiff has a no contact order in place from the incident of May 8th. Has she attempted directly or indirectly to you? Has she attempted to make contact with Keenan?
No, she has not that I know of.
Okay. Do you know, has Keenan attempted to make contact with her?
I've asked him and he said he hasn't.
What would you say if you would, since you had him on, since May 8th of 2023, have you noticed any changes in his personality or demeanor or anything of that nature as opposed to when he was alternating weeks?
No, I mean, I just noticed that he just seems happier and that, he's not as reserved and shy like he was and very outgoing. And all of a sudden he has all these friends that he loves hanging out with because he can actually go there and has someone to take him to spend time with his friends.
Okay. Does Keenan appear to enjoy being in your home on a full-time basis?
He does.
How do you know that?
He's told us he loves it here. This is where he wants to live. This is where he wants to be. And honestly, to be frank, he told us that if he has to go back there, he doesn't think he's going to. And I know, I've tried to talk to him about that. Like, if the court says you do, but he's adamant that he's not going back.
You said you had a loving relationship with Keenan. How does he exhibit that?
Oh, he'll give you a hug and tell you he love you, and you can't get out the door going, if you're going to the store or gas station or something real quick, he'll tell you. He makes sure he knows I love you every time before you leave, and every time you get off the phone. And like he'll come if me and Sam are in bed while watching TV. He'll come sit and just lay there and talk with us, and want to conversate and stuff like that.
How is his relationship with your fiance?
Very, very good. He calls her his stepmom, and they're very close. And they talk all the time. And when he needs something, if he's not coming to me, he's coming to her. And they were like that before he came full time since May 8th.
Is there anything else, sir, that you'd like me to be aware of?
No, sir. I think that pretty much covers it.
Okay. Ms. Reed, anything, any questions as a result of my questions?
No, Your Honor.
Okay. Thank you. Thank you, sir.
Thank
Ms.
you.
Reed, any additional witnesses?
Do we have Samantha in the waiting room?
Yes, Snyder, right?
What is the relationship to the parties in this matter?
I am Daniel Miller's fiance and Keon.
You're breaking up there a little bit, Samantha. Can you say that one more time?
Daniel Miller is my fiance
Okay.
and Keon is my stepson.
And how long have you been dating Mr. Miller?
Can you hear me okay?
Yes.
I can hear you now.
11, okay, almost 11 years.
Okay. And can you describe your relationship with Keon?
I'm sorry, could you repeat that?
Can you describe your relationship with Keon?
Oh yeah. Me and Keon are very close. I've been in his life since he's been about 2.5.
Okay, and what kind of activities do you two do together?
We play basketball, we play volleyball, we go to the beach, we go to South Haven. We just do everything together. He goes to the store with me, just anything you can think of, really.
Can you describe Keon's relationship with his dad?
Yep, they play football all the time. Daniel, he's very helpful in school. He's always making sure Keon has all of his assignments done. They play the video game together. We do a lot together as a family. We go to bonfires.
Okay, and how does Daniel show Keon love and affection?
By just being there for him, and anything that Keon might need to come, he's always there.
Okay, and Keon goes to Daniel for like life questions and things that he wants and needs?
Yes.
Okay. Does Mr. Miller have a stable home for Keon?
Yes, he does.
Okay, do you attend any of Keon's school activities with Mr. Miller?
Yes, every single one.
Okay. Do you know if Miss Keeler attends those activities?
I've only seen her at one of Keon's basketball games.
And that's throughout his entire life or just this year?
That was actually last school year. Throughout his life, it was hit or miss with her. She mainly did not come to any. I mean, it was very far in between that she would be there.
Okay, and how much contact do you have with Miss Keeler?
I have zero contact with her. She has my phone number blocked.
Okay.
Yeah.
Is there anything you would like the court to know?
Just that Keon is happy, healthy. He's in sports. He did good at the end of the school year last year. I just hope he gets to stay where he's at.
Do you have any concerns regarding Keon and April's care?
I do. I haven't seen a lot. Well, obviously with everything that's going on now with her criminal case with Keon, I do worry about him being alone with her. But as far as like before, I mean, she's not involved in any of his school. She's not involved in any of his sports. She's just not involved in his life. She doesn't want him to become, better. She does nothing to, I just hope that, everything turns out good for Keon today.
Okay, I have no further questions.
Okay. Ms. Snyder, I'll ask you, you said that the plaintiff has you blocked on her phone. Is that a result of any incident, altercation or anything, or did it just happen?
She's actually had my phone number blocked for, I want to say like 2 years now. She just, every time that I would try to communicate with her about anything to do with Keon, I believe it was over COVID. Keon, or I mean, the whole COVID, whatever. Well, Keon ended up coming over and he had headlights. And so I had mentioned something to April about, how could you let his headlights get so bad and send him over. And she just had me blocked ever since.
Okay. You broke up a little bit, ma'am, so I missed some of that. So you said there was an incident after COVID when she came over and you confronted her on the issue of headlights. And I think you were saying that that's when she blocked you. Is that correct?
Yeah, she became very irate with me and blocked me. Although she did unblock me towards the end of the school year to let me know that I needed to come pick Keon up and take him to school.
Okay, so there was one time when she unblocked you, she contacted you about taking Keon to school?
Yes.
Okay, Ms. Reed, any additional questions?
No, Your Honor.
Okay. Okay. Ms. Snyder, that concludes your testimony. Thank you. You're excused. Have a good day.
You too. Thank you.
Ms. Reed, any additional witnesses?
No, Your Honor.
Okay, then at this point, we'll conclude. Do you have any closing argument?
Yes, Your Honor. I think what we're requesting is appropriate considering everything that was been presented today and Ms. Keeler's behavior during today's hearing. It's not that she's been prevented from participating in her son's life. It seems like she's actively choosing not to. She's not participating in medical treatment. She's not participating in school. She didn't participate into the police officers' investigations regarding the incident in May. She's not participating with CPS or participating in any of the services offered by CPS, and for repeated attempts by everybody to contact her. It is in Keon's best interest to have parenting time reinstated with Ms. Keeler after that no contact order is lifted, after she has participated in and benefited from some anger management classes, some parenting time classes, undergoes an alcohol assessment, follows the recommendations of the alcohol assessment. And I do believe reunification counseling with an experienced counselor is going to be beneficial to help repair this relationship once she makes steps and efforts to help herself. So we're requesting that Mr. Miller have sole legal custody, and parenting time can be motioned by Ms. Keeler after she completes these steps, and that no contact order is lifted. For child support, I would again request that my client's employer remain confidential. I do believe Ms. Keeler is employed as a home health aide. We don't know where that is or how much she's how much she's making or what day she's working or if she has any other income.
Well, in this particular matter, as Ms. Reed notes, the first task of any court in a custody case, and the court will note that, again, there is currently a custody order for custody, parenting time, and support that dates back to 12/14/2020, and that did grant the parties joint legal and joint physical custody on alternating weeks as well as holidays. The court will note there was there was a lot of testimony in this matter that predates that order, so the court's not going to delve into much of that or give much substance to that, because the court is directed that the court has to go from the date of the last order unless the conduct or behavior that's being testified to is in fact to show some sort of a habit, routine, or other course of action on the part of the party. So the court's not going to go back beyond really that particular date. I know that, again, there was substantial testimony in this regard concerning that, but I'm going to go to that date and then go forward. In any case, the first job of the court, first task, is to determine whether an established custodial environment exists. An established custodial environment exists if over an appreciable time the child naturally looks to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the age of the child, the physical environment, and the inclination of the custodian, and the child as the primacy of the relationship shall be considered. Court can look at and note that there is the mere fact that the child is primary in one residence insufficient in and of itself to establish a custodial environment, because the custodial environment can exist in more than one home. This is important because when an established custodial environment exists, the legislature have enacted a clear and convincing evidence burden of proof to minimize the prospect of unwarranted or disruptive change of custody and to erect barriers against removal of the child from an established custodial environment. In this particular matter, the court, again, has heard the testimony in this case. There was an incident that occurred back on May 8, 2023, where the defendant was contacted at approximately 9:30. He said he was in bed, that he took the phone call, that it was from the child's grandmother, and that the child was crying and wanted to be picked up. He went over to the house to pick up Keenan, take it at the grandmother's house, that he was almost struck by the plaintiff going out of the driveway in her vehicle. That at that time, there was an altercation that occurred between the plaintiff and Keenan, that when he got there, he said he noticed that Keenan's face was red, his neck was red, and he had scratches on the back of his neck. There was, again, allegations of parental abuse that were investigated, or at least attempted to be investigated by the police department, that the plaintiff did not cooperate with the police department. When they went to her home, she talked to them through the door, did not open the door, did not allow them in, did not come out of the house. And at some point, she discontinued and failed to communicate with them at that point. Child Protective Services, we've heard the testimony in this matter of the Miss McCall, who testified that, again, she was the supervisor for Miss Hughes, who was the investigator or the ongoing worker in this particular matter. And that numerous and multiple attempts have been made to contact the plaintiff to investigate, and that in fact she did not communicate, she didn't respond. Even on one occasion, they did talk to her other 17-year-old daughter, and there was no communication back by her as it relates to the investigation. Court notes as well that it does appear, based upon the testimony that Keenan has been testified to by the defendant father, as well as testified to by Ms. Snyder, that Keenan and his dad have a very good relationship, a close bond, that I think Ms. Snyder said that at times Keenan will come in, simply be with the defendant, simply talk to him. The defendant had talked and testified as well that Keenan will talk to him. He'll be able to talk over things that are happening with Keenan, that he is able to give him some direction. He talked about discipline, that he would, in fact, give options to Keenan and say, okay, hey, you did this wrong. What do you think? We can do this, we can do that, that they talk about the discipline. There's testimony has been, as far as it relates to necessities of life and the material things, the defendant testified that since the May 8th date, the plaintiff has not contributed in any way to the financial assistance of Keenan. He stated he didn't want it, but he testified as well that it had not been offered, and she had not provided any assistance for Keenan as well. Based upon this, the court does believe that there's an established custodial environment with the defendant father in this matter. Court does note it's been a minimum time. We're talking approximately just over 2 months, but as I go through the factors, the court will highlight some of the other factors that go to this issue as well. But notwithstanding that, as we go through the factors, we'll be able to, again, highlight this a little better. First factor is the love, affection, other emotional ties existing between the parties involved in the child. The court will note that it is now in this matter is 3:10 p.m. that at approximately 2:24, the court noticed that the plaintiff was not on the video conferencing at that point. The court waited 10 minutes. That in fact she is still not joined or come back into this hearing, and the court will find that as a result she has abdicated various substantial responsibilities in this matter, and has failed to and has declined to present any evidence on her own behalf as it relates to any of the factors or anything in this matter, notwithstanding the fact that she had every opportunity and the ability to do so. She's not rejoined, she's not contacted the court's office, et cetera. And now it's been approximately 40 some minutes and she still hasn't joined. Court notes that talking about this matter, then the testimony of, again, the defendant and Ms. Snyder testified again about the loving relationship that the defendant and Keenan have, that, again, the defendant testified that, again, he'll hug the defendant, he'll tell him that he loves him, that he wants to go with him when he leaves the home and goes some places, et cetera. And the court does note that, again, it does appear that at the best, that there's a strained relationship with the plaintiff and Keenan, So the court will find that this factor does favor the defendant father. Next factor is the capacity and disposition of the parties involved to give the child love, affection, guidance, and continuation in the education and raising the child in a particular religion or creed. There's been testimony by the defendant that he doesn't have any religious involvement. As a result, the court will not consider that. The court will, however, note that, again, it does appear that the defendant has the capacity and disposition to provide Keena with love and affection and guidance, as we previously stated. Court does note as well, there's been testimony of both the defendant and somewhat a little bit about Ms. Snyder as it relates to, again, continuation in the education. Ms. Snyder did state that Keenan's happy, healthy, does good in school, or he did good in school. The testimony of the defendant was that during the time when the parties were alternating weekly parenting time and custody, that Keenan would not go to school 2 days a week, that he would not go when he was in his mom's care, that in fact he did not have assignments done, that when the Keenan came back to his home, that they had to work to get those assignments caught up, and he had to help him to get caught up because of the missed assignments. As a result, the court will find that the defendant this factor does favor the defendant father. Next factor is capacity and disposition of the parties involved to provide the child with food, clothing, medical care, other remedial care recognized in the place of medical care. In this case, the testimony has been that, again, the defendant testified he was the one that makes the doctor's appointments, that, in fact, in the instant, the evening that this incident occurred back on May 8, 2023, that the defendant was the one that took Keenan to the hospital to get medical attention after he had already been administered some first aid at the scene by ambulance. He did take him to make sure that there were no difficulties or problems with breathing. As he stated, he testified as well that he had, when the parties were alternating, that he would provide and he would go to the doctors and he would go to those particular appointments. The court would note, as I've mentioned previously, that since the incident on 5/8/23, the plaintiff has not provided any financial assistance for Keenan's care. And as a result, the court will find that this factor does substantially favor defendant father. Next factor is the length of time the child has lived in a stable, satisfactory environment and desirability of maintaining continuity. The testimony has been in this particular matter that the defendant's home is stable, that he lives in this townhome that he'd been in for approximately 10 years. It's 3 bedrooms. He lives there with his fiancee, Ms. Snyder, and her 2 children. Her 2 children share a bedroom, and Keenan has his own room. And the court would note that, again, there's no testimony from the plaintiff as to this particular factor. So the court can only extrapolate that, again, based upon the testimony, that this factor does, in fact, favor the defendant father. And I do that with the view that, again, there was obviously turmoil in the plaintiff's home or when she had the child that led to this particular incident occurring in May, in which a PA 53 and a no contact order went into place, and she could not have contact with Keenan. Next factor is the permanency of the family unit existing or proposed custodial homes. In this matter, the testimony of Ms. Snyder and Mr. Miller has been that they have been together for approximately 11 years. She is his fiancée, and it doesn't appear that there is any again, lack of permanency or any potential upheaval in that home. In the plaintiff's home, the court doesn't have any testimony as to the permanency of the family unit in the home. So the court will find that this factor does weigh in favor of the defendant father. Next factor is the moral fitness of the parties involved. There's been testimony of the defendant that the plaintiff has an alcohol issue. He referenced that there was, again, an incident that occurred prior to the last order in this case. I just want to clarify that occurred back in 2010, and then she ended up entering a plea on April 28, 2011 to a drinking driving offense which caused injury, to which she was incarcerated for 3 years. Court notes that the court will look at this even though it predates the last order because, again, it shows a course of conduct or habit or other routine, if you would, on her part of having involvement with drinking, and in that case, drinking and driving to a point where on the night of the May 8th date that she came out of the driveway, almost striking the defendant's vehicle as she left the residence. There's not been any testimony about any issue of moral fitness on the part of the defendant. As a result, the court will find that this factor does weigh in favor of the defendant father. Next factor is the mental and physical health of the parties involved. There's been little of any testimony other than defendant that he has no mental or physical health issues. The court can't, based upon any testimony in this matter, I guess you'd say, extrapolate any finding as it relates to the plaintiff. So the court's not going to weigh this factor in favor of either party in this matter. Next factor is the homeschool and community record of the child. The testimony has been that the child does go to school, that in fact he's involved in basketball, he's involved in football, that he had good attendance when he was in the defendant's home and good attendance since then. There was also testimony that when the parties were alternating weeks, that the defendant's grades were C's and B's. However, once at the end of the year, when the child was only in the defendant's care, his grades ended up at the end of the year as B's and A's. In this matter, there was testimony substantially about the defendant's involvement in school and the homework and getting those assignments done and all of that. And we don't have any testimony from the plaintiff as it relates to this, but again, we can always expound on the fact that Keenan missed 2 days a week when he was in her care, that he had missed assignments that necessitated the defendant catching up on that. As a result, the court will find that this factor does favor the defendant father. Next factor is the reasonable preference of the child. If the court considers the child to be a sufficient age to express a preference, I did have an opportunity to speak to Keenan, and court does find him of sufficient age and maturity to express a preference. I'm taking that into consideration. Next factor is the willingness and ability of each of the parents to facilitate a close and continued parent-child relationship with the parent and the other child. In this matter, the court will note there is very little testimony about this. It does appear that when the parties were alternating weeks, that they were able to accomplish that, being able to do that. And as a result, the court will find that this factor does not weigh in favor of either of the parties. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the child. Obviously, in this case, there would have been some testimony about a domestic violence incident occurring many years ago when the parties, before the last order in this case involving the parties. But in this particular case, there was directly testimony by Ms. McCall, by, again, Officer LaValley, as to, again, domestic violence directed by the plaintiff against the minor child. Testimony was that by Officer LaValley that she'd gotten a report, or she responded to that. She noted that Keenan had scratches the back left side of his neck that he had been being administered to by first aid, and that there was testimony of the defendant that consistent with that, and that he took Keenan to the hospital, again, to eliminate the possibility of any other injuries. And as a result, the court does find that to be very significant and substantial, and will weigh this factor substantially in favor of the defendant father. Next factor is any other factor considered by the court to be relevant. The court notes in this matter that I probably addressed all of these particular factors, but the court is,
Your
again.
Honor, I think we lost my client.
Oh,
Yeah, we just lost him just now.
okay, Mr. Miller, I thought you left us too.
No, sorry, my phone froze. I think I
Okay,
getting kind of warm.
okay. The last factor is any other factor considered by the court relevant in the particular dispute. The court does note in this matter that, again, I've addressed most of it in the other factors, but I do note in this matter that Ms. Snyder testified that she'd been in Keenan's life since he was approximately 2.5 years old. That again, there's a good family unit with her children and Keenan, And she testified about the close relationship that she has with him. The court notes that, again, what the court deems that to be somewhat relevant. Also relevant is the fact that the plaintiff, throughout the course of this proceeding, commencing with the incident that occurred on May 8, 2023, she's effectively not participated in anything. She did not participate in the police investigation. She's not participated with Department of Health and Human Services, Child Protective Services, that they attempted to get her involved, had multiple occasions where they had made multiple calls, multiple attempts to meet her at her residence, that she did not participate, that she has not returned any of those particular calls. And again, then leaving the hearing today and not rejoining, it does appear that she has in fact abdicated any and all involvement with Keenan in this particular case. So the court is taking that into consideration. In this matter, the court would note, which I didn't know when I was talking about the domestic violence, the court would note that CPS and their involvement did substantiate parental abuse in this particular matter, and I wanted to make sure that I address that going to factor K. When the court looks at this testimony, the court does believe that, again, based upon finding an established custodial environment with the defendant, that the defendant need only show by a preponderance of evidence that it is in Keenan's best interest to be in his custody. The court will find that the factors, and as we weigh the factors, are overwhelmingly favor the defendant, and the court will find that, again, clearly he's even established by clear and convincing evidence that it is in Keenan's best interest to be in his care. The court will find that, again, clear and convincing evidence is evidence in which would produce in the mind of the trier of fact a clear conviction without hesitancy as to the truth of the precise facts at issue. The court does find such a factor and such evidence presented in this particular case. And as a result, the court will note, and I will address the issue of legal custody. In this matter, the testimony has shown that the plaintiff has failed to communicate with the defendant. He has testified that, again, she has blocked him on her phone. Ms. Snyder has testified that she's been blocked from plaintiff's phone after simply an incident bringing up the issue of head lice to her, and that she was blocked. However, the court would note that when the plaintiff did want to communicate with defendant or Ms. Snyder, that she would unblock him for purposes of doing that and then block him again. So clearly she has not attempted to or wants to communicate. And as a result, what the court believes that it is appropriate that the court will grant to the defendant sole legal and physical custody in this matter. As noted at the commencement of this proceeding, the plaintiff does have a PA 53 and a no contact order in place that she cannot have contact with the child because of the pending charges. But in this matter, the court does believe, based upon her behavior, based upon her interest and willingness to be involved, to participate and, again, receive any more part of services that would, in fact, prepare her to have Keenan back in her care, and that she has failed to do so, that the court does believe that it is appropriate at this time that the court not grant any parenting time until such time in the future as she should petition and the court find that it is appropriate to grant parenting time. The court will, I have addressed that, but the court will address the particular parenting time factors just for purposes of getting those on the record. And parenting time is to be awarded pursuant to MCL 722.23A, and the court has to go through the various factors in this matter. Those factors being: one, special circumstances or needs of the child, which there are none at this point. The child is age 13, so the second factor is not applicable. Next factor, likelihood of abuse or neglect of a child during parenting time. Clearly, that factor would preponderate in not having parenting time. Likelihood of abuse of a parent during the exercise of parenting time. There's been no testimony about that. Next factor, inconvenience or burdensome impact of travel. There's been no testimony about any of that, so the court will not consider that. Next factor is whether the parent is reasonably expected to exercise ordered parenting time. Again, there's been no testimony that the parties, when they were switching on an alternating basis, that the plaintiff didn't exercise parenting time, so the court will take that into consideration. Next factor is whether parents frequently fail to exercise parenting time. And again, I'm not going to ascribe anything to the plaintiff in this matter because she has a no contact order, and there's been no threatened or actual detention of the child, so that's not applicable either. Although any other relevant factors, as there was under the Child Custody Act, the court will note that the plaintiff has done nothing in an attempt to reestablish contact with the child or to have placed herself in a position where she could have parenting time, and the court's taking that into consideration as it relates to my determination that there should be no parenting time awarded in this case. The court will proceed with the little that I have as it relates to child support. The testimony of the defendant is that he works 40-hour week at $24 per hour, that he has no bonuses, no overtime, no other benefits in this particular matter. We don't have any testimony other than mentioned in closing, but the court does note that based upon the current labor climate, as court does every week in dealing with instances where parties are not employed and not paying their support obligations, that in fact there is substantial need for employees, that in fact almost every business has a help wanted sign, and that is probably the best time ever in history to get employment. So whether she is employed or is not employed, the court will note that she does have the ability to acquire employment. The court will note as well, we don't have any notice as to what her income is, but the court can, based upon, again, the business and job climate, can impute income of $15 per hour to her, which I will do at this point for purposes of getting the support instituted in this matter. If it turns out in the future that there's other information as to her making greater income than that, the court would take that into consideration for purposes of modification as well. With that, I believe that the court has addressed all of the issues the court needs to address. Ms. Reed, is there anything you believe that the court has missed or have failed to address before we conclude?
Will the court be ordering Ms. Keeler participate in any anger management parenting time classes or an alcohol assessment before she petitions the court for a reinstatement of parenting time?
I'm not gonna address any of that at this time because I've not ordered any parenting time. That the court will address that at that time if it's appropriate.
Okay, I don't have any questions.
Okay, Ms. Reed, I'll ask that you would prepare the appropriate orders, submit those to the front of the court for approval, and then to the court. Mr. Miller, best of luck to you. I hope everything works out, and court will conclude this matter at 3:34 p.m. You're free to go. Have a good day.